She was sitting in the last row of a federal courtroom in Manhattan, and nobody looked at her twice. That was the point. Plain linen blazer, dark hair pinned back, a worn Kindle in her lap. The kind of woman that rooms full of expensive suits tend to look through rather than at. Then the lead prosecutor came clicking down the marble hallway during recess. She stopped at the water fountain. She looked at the woman the way people look at furniture they did not order. She said, loud enough for the three attorneys behind her to hear every single word, "Excuse me, this gallery is reserved for legal professionals and press. If you are here about the cleaning schedule, facilities is on the third floor." The woman looked up from her Kindle. She looked at the prosecutor for one long, steady moment. She did not explain herself. She did not correct the prosecutor. She did not say a word. She just closed her Kindle, stood, and walked back into the gallery, back to the last row, back to her seat. And then she opened the Kindle again and went back to reading, like the prosecutor was already irrelevant, because she was. In 40 minutes, that prosecutor's entire career would be over. And the woman in the linen blazer, the one everyone had just looked through, would be the reason why. But the real twist is not what she did in that courtroom. The real twist is what she had already done the night before, alone, at a kitchen table at 11 in the evening, while the most feared judge in the Southern District of New York was in the next room reading case files. Stay with me, because this story is going to give you chills from the inside out. Her name was Wren Calloway-Ashford, 29 years old. And before I tell you what she was doing in that courtroom, I need to tell you what they took from her, because you need to understand the full weight of what she was carrying the morning she sat in that last row and said nothing. 3 years ago, Wren was a rising federal case analyst at one of Manhattan's most powerful civil litigation firms, a place called Hargrove and Steele. Italian marble in the lobby, oil paintings of founding partners who looked like they had never been questioned about anything in their lives, the kind of firm where you were supposed to be grateful for the oxygen. Wren was not there to be grateful. She was there because she had graduated top of her class from Brooklyn Law at 24 and had earned every single thing she had by reading the actual case files instead of the summaries and staying in the library until they turned the lights off. For 2 years, she built cases the way other people build cathedrals. Careful, exact, one document at a time. And then, at 26, she found something she was not supposed to find. It started with a single expert witness report. The numbers were wrong, not by accident. She pulled the underlying data, then the source documents, then the academic papers. She worked on it for 6 nights in a row at her desk in a studio apartment in Crown Heights, cold Starbucks coffee forgotten at her elbow, until she had documented 22 separate instances across 9 civil cases where senior partner Edward Hargrove had directed expert witnesses to alter their findings, not clarify, alter, to benefit his clients, at the cost of ordinary people on the other side of those cases. A woman who lost her small business, a family who lost their life savings, real people who had trusted the system. Wren reported it, first internally, then to the state bar, then to federal oversight. And Edward Hargrove, who had been practicing law for 30 years and whose name was on half the donor lists in Manhattan, did what men with that kind of power always do when someone smaller tells the truth about them. He destroyed her. Her license was flagged. Her name was circulated on lists that nobody admits exist. Anonymous sources fed stories about her being unstable, vindictive, difficult. She was 26 years old and she was already finished before she had properly started. She did not collapse. I want you to hear that clearly. She did not collapse. She did not collapse. She got a job as a document reviewer at a small firm in Brooklyn for $18 an hour. She annotated cases on her Kindle on the subway. She read Marcus Aurelius in the evenings, not because it was fashionable, because there was a line she had written on a legal pad she kept on her nightstand, a line that said, "The impediment to action advances action. What stands in the way becomes the way." She was not waiting to be rescued. She was waiting for the truth to catch up. It was a rainy Tuesday in October. 14 months. The speaker was a federal judge named Declan Ashford, 44 years old, silver at his temples. The kind of man who commands rooms, not by filling them with noise, but by making everything else in the room feel slightly less certain of itself. He was explaining a framework for judicial impartiality when the moderator asked a question that Declan paused on. A rare pause. The room noticed. 34. The fast. And from the third row, quietly, without raising her hand, Wren said the precise phrase that completed his thought. He looked at her. The entire room looked at her. She was already writing something in the margin of the brief in her lap. He walked directly to the third row after the lecture. He said, "That was the clearest articulation of the impartiality doctrine I have heard in 20 years of practicing it." She said, "It was in your footnote. You just did not say it out loud." He smiled, just barely, like a man who had forgotten he knew how to do that. That was how it started. 14 months later, they were married, quietly. City Hall on a Wednesday afternoon. 2 witnesses. No announcement, no press. Wren had asked for it this way, and Declan had nodded before she finished the sentence, because he understood it in his bones. She would not be known as the judge's wife until she was known as herself first, until her name was clean. She was not going to borrow his power. She was going to earn her own. And so for 14 months, she had been his wife in private and a ghost in public. She came to his high-stakes courtroom sessions sometimes, quietly, in the last row, just to be near him on the days when the law was being tested. She had never spoken in that courtroom, but she had done something the night before that would change everything. The case was United States versus Riordan. Martin Riordan, a real estate developer who had sold fractional investment shares to 340 working-class families in Queens, and then watched their savings disappear into shell companies while he drove home to Connecticut. 2 years of federal case building. This was the trial. The prosecutor was Sabrina Voss. Sabrina Voss was 38, polished, and politically ambitious in the way that turns everything into a performance. This case was supposed to be her crown jewel, a clean conviction, a story about justice, the kind of story that gets you a federal appointment. She was very good at performing. She was not as careful with the documents. From the bench, Declan Ashford listened to her morning presentation with the stillness of a man performing surgery. Every ruling precise, every word measured. He had presided over federal cases for 11 years, and he had never once allowed personal feeling to enter that courtroom. It was not a boast. It was a discipline he renewed. Every single morning he put on the robe. But at 11:23, during Sabrina's presentation of Exhibit 14, something caught his eye. The transaction date on the exhibit read March 7th. Declan had reviewed the public archive the previous evening, as he always did before a high-stakes session. The original wire transfer record in the Federal Financial Archive showed March 4th, 3 days. Just 3 days. But in a chain of custody argument, 3 days was the difference between conviction and nothing. The defense attorneys from the politically connected firm of Caldwell and Associates had not caught it yet. They were watching the jury, but they had 3 analysts on their team, and when one of them finally looked at the exhibit timeline against the public record, the prosecution's case would fall apart. And Martin Riordan, the man who stole the savings of 340 families, would drive back to Connecticut with his lawyer's hand on his shoulder. Declan could not tip Sabrina off. He could not speak to attorneys outside of official procedure. He could not raise an eyebrow. He could only preside. Then came the first recess. Sabrina used it to come back down the marble hallway and do what we already saw. She found the quiet woman at the water fountain and she announced, loudly, that the gallery was for legal professionals only, and was she perhaps there about the cleaning schedule. 3 attorneys heard it. One of them laughed quietly. Wren said nothing. She went back to her seat. In the clerk's bench, Marcus Webb had seen it. His jaw was tight as he slipped out of the courtroom and walked to the north corridor where Wren was standing at the tall windows overlooking Center Street. He passed her without eye contact and placed a folded note on the windowsill beside her hand. She picked it up. She read it. The note said, "He sees it. He cannot fix it. You might be the only one who can." Wren stood very still, and then a small, quiet, almost invisible smile moved across her face. Because she had caught the date discrepancy herself the night before, at exactly 11:19, sitting at the kitchen table of their apartment on West 74th Street, cross-referencing the prosecution's exhibit list against the public archive on her MacBook Air the way she always did the night before Declan had a high-stakes hearing. She had written a 3-page memo. She had placed it on his pillow. She had come to bed and told him one sentence: Exhibit 14, transaction date, March 7th in the submission, March 4th in the public archive. He had read the memo and held her face in both hands and said something to her in the quiet of midnight that she was still carrying in her chest as she stood at the north corridor window. She put the note in her blazer pocket. She went back to her seat. She knew exactly what she was going to do. To understand what was happening inside Declan Ashford on that bench, you need to understand who he was before he became the man in the black robe. He had been married once before, a woman named Genevieve, beautiful, socially fluent in all the rooms that Declan was not. He had trusted her the way you only trust someone when you have decided they are the exception to every rule your experience has taught you. He had been wrong. She sold sealed case information to a competing law firm. Not once, 3 times. Information that was used against people in connected civil proceedings. In one case, a witness whose location appeared in those sealed documents was found and threatened into silence. Declan found out the night before the story broke publicly. He presided over the trial that convicted the firm partner involved. He sat in the gallery with the stillest face anyone in that building had ever seen on a human being. He divorced Genevieve on a Thursday. He came back to the bench on a Monday. He never spoke about it publicly again. What happened after that was this. Declan Ashford became the most feared, impartial judge in the Southern District of New York because the only thing you could reliably count on from him was that he would rule on the law as it existed and not as anyone needed it to be. He had no political ambitions. He attended the events he was required to attend and declined the ones he was not. He drove a 6-year-old black Mercedes and read during lunch and stopped, carefully, deliberately, wanting things that could be taken from him. And then a woman in the 3rd row of a lecture hall finished a sentence he could not complete, and he went home that night, unable to stop thinking not about the answer, but about the fact that someone exists who reads the footnotes. He had called her the following week. They had coffee, then lunch, then dinner at a quiet West Village restaurant where he told her he knew about the DOJ internal review. He said, "It was sealed, but I know it existed, and I know what it found. Your documentation was sound. They buried it." She had looked at him in the candlelight for a long time, and he had reached across the table and placed his hand over hers, and she had understood that he was not offering her rescue. He was offering her witness, the acknowledgement that she had been right, from someone with the standing to say it. It was the most precise form of love he knew how to give at that point. She had understood it exactly. Now, at 11:52 in the morning, sitting on the bench of Courtroom 14B, with his Mont Blanc pen perfectly still in his hand, Declan Ashford was doing something he had not done in 11 years of judicial service. He was angry. Not the sharp professional anger that occasionally entered a ruling when counsel was wasting the court's time. This was something else, quiet and dense and very old. It lived underneath the discipline and the robe and the 11 years of careful impartiality. And it was the anger of a man who had watched the woman he loved, the woman who had spent 3 years rebuilding herself from the wreckage that people like Sabrina Voss's donors had created, be publicly spoken to, like staff, in his building, in his hallway, in front of his clerks, 40 feet from where he sat. He had watched it from the bench through the open gallery door. He had seen every word of it. He could not react in court. But during the second recess, Declan Ashford did something that Marcus Webb would later say was the only time in 11 years he had ever seen the judge move with something other than complete judicial composure. He stepped out of chambers, and he found Sabrina Voss in the conference corridor before she could return to the prosecution table. He stopped in front of her. He was in his judicial robe. He was 6 feet tall, he said, in a voice that was completely level and absolutely clear. "I am aware of what happened in the hallway during the first recess. I am telling you this not as a judicial instruction, but as a matter of professional courtesy. This court notices everything. You would do well to conduct yourself accordingly in every corridor of this building, not only inside the courtroom." He did not raise his voice. He did not threaten her. He said nothing that could be reported as improper. He just stood in front of her in the conference corridor until she understood that she had been seen, and then he walked back to his chambers. Sabrina stood very still for 4 seconds. Then she went back to her table and sat down and began, with great precision, to think about who the quiet woman in the last row actually was. That was her second mistake. Her first was the cleaning schedule comment. Her third would end her career. Sabrina spent the lunch recess on the phone. She had a contact at a legal gossip publication who owed her a favor. By 1:15 in the afternoon, she had a name: Wren Calloway, former case analyst. Hargrove and Steele, the bar complaint, the very public professional destruction, the damaged reputation. She did not yet know about the marriage. She did not know the name was now Calloway-Ashford, but she knew enough. She knew that the quiet woman in the last row had a history that could be used. She called a surprise character witness at 1:17. His name was Jeffrey Park, a senior associate at Hargrove and Steele. Polished, composed, the precise image of a man who has given enough depositions to know exactly how much sincerity to perform without overdoing it. Sabrina established his credentials. She established his familiarity with the firm. And then she asked, "Are you familiar with an anonymous complaint filed against Hargrove and Steele approximately 3 years ago?" He said, "Yes. Us. He described it as the product of a former analyst whose combative behavior made professional relationships difficult. He used phrases like pattern of escalation and insufficient substantiation, and colleagues who observed concerning conduct. He never said Wren's name. He did not need to." Sabrina glanced toward the gallery as he testified, and the gallery shifted. A legal reporter pulled up archived articles on his phone. A junior associate from another firm leaned in toward his colleague. Someone in the press section typed something, and then, slowly, like cold water spreading across a floor, heads turned toward the back row, toward the woman in the linen blazer, toward Wren. Wren felt every single pair of eyes that moved to her. She sat perfectly still. Her back was straight. Her hands were folded over her Kindle. Her face was the face of someone who has been through the worst version of this before, who has sat in rooms where her name was being arranged into a shape she did not recognize, who has felt the particular cold of being publicly unmade and learned, through 3 years of practice, that the only thing that cracks under that kind of pressure is the thing you were pretending to be. And Wren was not pretending to be anything. She was exactly who she was. She was the woman who found the discrepancy at 11:19. She was the woman who wrote the memo. She was the woman who had been right for 3 years, while the room insisted she was wrong. She breathed. She thought of the line from her Kindle. "You have power over your mind, not outside events. Realize this, and you will find strength." She did not look at the floor. She did not look away. She let the room look at her, and she gave it nothing to find. And then, it happened. The thing that Carter Webb, the legal reporter in the gallery, would say later changed the entire atmosphere of the room without anyone fully understanding why. Declan lifted his eyes from the bench. Just for 3 seconds. He looked across the courtroom, past the attorneys and the jury box and the 30 people in the gallery, to the last row. To the woman in the linen blazer with the Kindle in her lap and her back straight as a ruling. He found her eyes. She was already looking at him. 3 seconds. Just 3 seconds in a federal courtroom with 30 witnesses who saw it, and none of them understood. what they were watching. The most feared impartial judge in the Southern District of New York looked at the back row and let her see, just for a moment, that under the robe and the title and 11 years of discipline, he was a man who would have burned the whole building down before he let her be treated this way. If burning things down had been the right answer. It was not the right answer. The right answer was what they had planned at midnight. The right answer was already in motion. But he wanted her to see that he knew, that he was not absent, that every second of what was happening in this room was landing on him. She held his gaze for 3 full seconds, and then she gave him the smallest nod, a nod that said, "I am fine. I have survived worse than this room. Do your job. I trust you." He turned back to the bench. He picked up his Mont Blanc pen. His voice when he spoke was exactly what it always was, level, clean, the voice of someone who has made peace with the fact that the room belongs to the law. He said, "The court notes that the character testimony entered is not directly material to the evidentiary matter before this court and will be weighed accordingly." It was the closest he could come. Within every line he had spent 11 years refusing to cross. Sabrina Voss sat down with the satisfied expression of someone who believes they have just scored a point. In the gallery, Carter Webb set down his phone and picked up his notebook. He wrote one word and underlined it, wife. He did not yet know how right he was. Let me take you back to the night before. West 74th Street, Upper West Side. The apartment that Declan had moved into 9 years ago and that Wren had moved into 14 months ago, bringing with her 3 boxes of documents, a large plant she had nursed through 2 Brooklyn winters, and a worn copy of Meditations underlined in 3 colors of ink. It was not a showpiece apartment. It was the apartment of 2 people who used their square footage for working. Stacks of legal books on every flat surface. A living room window that faced west and caught the amber light at the right hour. A kitchen table large enough for 2 people to work at simultaneously, which they did most evenings. Declan had come home at 8:47. The first thing he always did was set his Mont Blanc pen on the kitchen counter. Just that. The pen on the counter. It meant, I am home. I am a person now, not a position. She was at the table. Cross-referencing the prosecution's exhibit list for U.S. versus Riordan against the Public Financial Archive documents, he sat across from her and opened his own case files. They read. They worked. The city moved below them. At 11:17, she said his name. He looked up. She turned the MacBook Air toward him. She put her finger on the document on the screen. Exhibit 14. Transaction date. March 7th in the prosecution submission. March 4th in the Public Wire Transfer Archive. He looked at the screen. He looked at her. She said, "It is not a typo. A typo does not match the date of a different transaction that happens to benefit the defense interpretation of the timeline." This was changed after submission. He was quiet for a long moment. Then he said, "If the defense finds this before the prosecution corrects it, the chain of custody falls apart." She said, "Yes." He said, "I cannot act on information outside the official record." She said, "I know." He said, "And you cannot present yourself to the court or to counsel." She said, "I know that too." She was already reaching for the legal pad. She wrote for 38 minutes, 3 pages, precise, documented. Every archive reference number, every document ID code, every page and paragraph location in the public financial database where the original wire transfer record sat, intact and contradictory and fully accessible to anyone who knew where to look. She walked to the bedroom. She set the memo on his pillow. She said, "Someone in that courtroom tomorrow needs to know where to look. They just cannot know it came from here." He took the memo. He read it. Added, "RS." He set it down. He took off his reading glasses and looked at her across the bedroom in the quiet of 11:55 at night. And she saw in his face the thing that she had been slowly learning to read over 14 months. The thing underneath the composure. The thing that was only ever visible when it was just the 2 of them. He stood up from the bed. He crossed the room. He cupped her face in both hands, his thumbs on her cheekbones, and he looked at her the way you look at something you were afraid you might lose. before you fully understood how much you needed it. He said, "When this is over, I am going to stand up in whatever room you want and introduce you as the most formidable legal mind I have ever encountered." She said, "Not yet." He said, "Not yet." She said, "When my name is clean." He said, "Then let us make sure your name gets clean." She put her hands over his. Outside, the city moved through its nighttime rhythms. In the morning there would be a federal courtroom and a case with 340 families waiting on its outcome, and a prosecutor who did not yet know what was waiting for her. But that was the morning. This was the night before. And in the night before, they stood very still in the half-light of the bedroom and did not need anything else, because the thing between them had passed beyond the need for language and into the territory of simply being true. The following morning, at 7:45, Declan called Marcus Webb. He said, "I have a procedural courtesy note I would like you to prepare for defense counsel. Regarding publicly accessible financial archive materials that may be relevant to Exhibit 14, March records. Document reference 4471. B-March 04. Marcus said, "I understand." Declan said, "It is entirely standard practice. Nothing more." Marcus said, "Of course, Your Honor." At 11:46, during the recess, Marcus placed a folded note on the defense table in front of the junior associate from Caldwell and Associates. The note indicated that the publicly accessible wire transfer records in the Federal Financial Archive March series were available for review in the archive room on the second floor. The junior associate looked at the note. He looked at it for 4 seconds. Then he stood up very quickly. He was back 11 minutes later. His face was the color of the marble hallway. He handed the lead defense attorney a printed document with 3 lines highlighted in yellow. And when court resumed, the lead attorney stood and said, "Your Honor, the defense would like to request a recess to review newly identified discrepancies in publicly available financial documents pertaining to Exhibit 14, which we believe are material to the prosecution's chain of custody argument." The room went very still. Sabrina Voss's pen stopped moving. Declan said, "Recess granted." He did not look at the back row. In the back row, Wren had closed her Kindle and folded her hands and was waiting for what she had known was coming since 11:19 the previous night. The recess lasted 38 minutes. The lead defense attorney from Caldwell and Associates came back into the courtroom with a highlighted printout and the expression of a man who has found exactly what he was hoping to find and then found more besides. Court resumed. He stood and said, "Your Honor, the defense has identified a material discrepancy between Exhibit 14, as submitted by the prosecution, and the publicly accessible wire transfer records in the Federal Financial Archive. Document reference 4471. B-March 04. The prosecution's exhibit records a transaction date of March 7th. The original archive document records March 4th. This is not a clerical error. It directly affects the prosecution's chain of custody timeline as presented to this court, and the defense contends it constitutes a material alteration of submitted evidence. Sabrina Voss was on her feet before he finished. Controlled, smooth. She said the defense was drawing speculative conclusions from documents whose provenance had not been established before the court. Declan said, "The Federal Financial Archive is a federally maintained public record. Its provenance is established by statute." She said there might be a clerical explanation for the apparent variance. Declan said, "Counselor, can you explain the variance between the original submission date on Exhibit 14 and the date reflected in the publicly available archive record?" She opened her mouth. She closed it. She looked at her associates. The junior associate on her left shook his head by 1 millimeter. The one on her right was already on her phone, under the table. She said, "Your Honor, I would need time to review the documentation before making a statement on the record." Declan said, "The court will note your inability to explain the discrepancy at this time." He set his pen down. He looked at the courtroom. Not at Sabrina, not at the defense table, at the room, at the marble and the wood and the seal on the wall, and the 30 people in the gallery and the architecture of a system that was supposed to be larger than any one person's ambition, he said. The court is referring this matter to the Office of the Inspector General for the Southern District of New York for review of potential irregularities in the prosecution's exhibit submissions. The current proceedings are suspended pending that review. All parties are instructed to preserve all related materials. This court is adjourned. He struck the gavel. One sharp sound. Wood on wood. The sound of the law, ending a sentence. The room erupted quietly, the way federal courtrooms erupt, in phones and leaning conversations and people pulling on coats and the electric particular buzz of people who understand they have just watched something that matters. Sabrina stood at the prosecution table for 12 seconds without moving. Then she reached for her portfolio and began, with tremendous precision, to pack it. In the gallery, Carter Webb had his notebook open and his phone out and was already 3 steps ahead of the story that everyone else was still catching up to. Because Carter Webb had been in enough federal courtrooms to know that material alterations to submitted exhibits do not usually happen in isolation. They happen inside systems of pressure and interest. And Sabrina Voss had just been caught with a falsified exhibit in a case where the defendant was represented by a politically connected firm. He typed her name into his phone. He pulled her campaign finance disclosures. The first result that came back was a political action committee contribution from 3 years prior, $42,000, from Edward Hargrove of Hargrove and Steele. Carter Webb sat very still for 1 full second. Then he looked at the gallery. At the back row, it was empty. The woman in the linen blazer was already gone. He looked back at his phone. He typed, Wren Calloway-Hargrove Steele bar complaint. He found the archived legal press items, all anonymous sourced, all hostile, all tied to Hargrove Associates. He found the procedural footnote in a later case filing that referenced a sealed DOJ internal review and noted that the original complaint had been found to be substantively sound. He sat on the bench in the emptying gallery of Courtroom 14B and understood that he had been in the room where the end of a 3-year story was playing out, and the central character had been sitting 15 feet behind him the whole time, reading her Kindle. He wrote in his notebook, below the underlined word wife. She was right. They knew it. They buried it. Hargrove funded Voss. Voss altered the exhibit. The woman in the last row is the thread that connects all of it. He closed the notebook. He picked up his phone and called his editor. He said, I need a full page. Wren walked out of Courtroom 14B at 12:47, through the gallery exit and into the marble hallway, moving with the quiet efficiency of someone who has always known where the door is. She was 15 feet from the building exit when she heard heels behind her. Quick, purposeful. She stopped. She did not turn around. She waited. Sabrina Voss stopped 3 feet behind her. She said, low and hard, somehow you did this. Wren turned around. She looked at Sabrina Voss. The perfect blazer. The perfect hair. The face of someone who has, in the last 30 minutes, understood the nature of what she has lost. Wren said, no. She said it the way she said everything, quietly, without performance. She said, you did this. The moment you changed a date on a federal exhibit and filed it as evidence, I just happened to read the original. Sabrina stared at her. Wren held her gaze for 1 second. Just one. Then she turned and walked out of the building without looking back. There was nothing behind her worth turning around for. Declan came out of the courthouse at 1:15. Marcus at his side. The black Mercedes at the curb. The March air cold and gray and exact. Carter Webb was on the steps. Notebook out. He said, Judge Ashford, I want to ask you about the exhibit discrepancy, but I also want to ask you about something else. The anonymous complainant in the Hargrove and Steele matter 3 years ago. The analyst whose complaint was vindicated in a sealed DOJ review. Is she Wren Calloway? And is she your wife? Declan was still for a moment. The kind of stillness that is not absence. The kind that is full presence. Completely concentrated. He said, My wife is Wren Calloway-Ashford. She is a former federal case analyst of exceptional integrity and precision. She documented genuine misconduct at significant personal and professional cost. The DOJ review vindicated her findings completely. She has always been right. She did not use my name to seek recognition or protection. That was her choice, and I respected it. But I will say this clearly and for the record. The people in this city who decided 3 years ago that a 26-year-old woman telling the truth about a powerful man was the problem rather than the powerful man, those people were wrong. The record will show they were wrong. And her name, her actual name, is the one that will be standing when this is done. He got into the Mercedes. Carter Webb stood on the courthouse steps in the cold and looked at his notebook for a long time. He wrote one more line. He wrote, "She was always the story." 3 hours after that, Judge Patricia Osei called Wren's cell phone. Patricia Osei, who had served on the bar panel when Wren's original complaint was buried, who had said in the closed session that the documentation was credible and had been outvoted, who had lived with that for 3 years. She said, "The expedited review has been formally requested, and I have agreed to participate. I expect completion within 48 hours. And I want you to know that I have wanted to make this call for a long time." Wren said, "I know. Thank you, Judge Osei." She hung up. She sat at the kitchen table on West 74th Street with her phone in her hand and the amber light coming through the west window and the city below moving through its ordinary evening, entirely unaware that anything had changed. She did not cry. She just breathed. One slow breath in, one slow breath out. After a while, she reached for her Kindle. She opened it to a page she had read many times. She read for 20 minutes. Then she set it down and waited for the pen to come home. 48 hours later, the letter arrived from the New York State Bar. 3 paragraphs. The third paragraph said that following an expedited review of all relevant materials, including the sealed DOJ internal assessment and documentation pertaining to coordinated reputational damage by associates of Hargrove and Steele, the bar had determined that the original complaint filed by Wren Calloway had been substantively sound, and that adverse proceedings against her license had been improperly pursued. Her license was fully reinstated, effective immediately. All restrictions removed. All adverse notations expunged from the official record. She read both sentences twice. She folded the letter and held it in both hands for a moment. Then she set it on the kitchen table, exactly in the center, where the amber light hit it in the afternoon. Marcus texted at 9:14. "It is done." She replied with a single period. He sent back a period. That was all. She did not call anyone. She did not post anything. She just sat at the kitchen table in the morning, quiet of the apartment, and let it settle into her, the way warmth settles in after you have been cold for a very long time. It had taken 3 years. Truth had waited for her. It had kept the receipt. And now it had delivered. He came home at 6:47. She heard the key in the door. She did not turn around. She was at the kitchen table where she always was, the Kindle open beside a cup of tea, a legal pad to her right, already half covered in the small, precise handwriting that would become the first brief she wrote as Wren Calloway-Ashford, attorney, fully licensed, name clean. She heard him come through the hall. She heard him set down his briefcase, and then the small, particular sound of the Mont Blanc pen placed on the kitchen counter, the pen on the counter, the sound of him arriving. She looked up. He was in the doorway, work shirt, dark trousers, jacket over one arm, tie loosened, the face of a man who has spent the day holding the weight of the law and is now carefully setting it down. He walked to the table and sat across from her. He reached into his inside jacket pocket and placed something between them. It was a copy of the bar notification. Not her copy. A copy that Patricia Osei had sent him with a handwritten note that said, "I thought you might want to hold this one." He said, "It is done." She said, "I know. I got the letter this morning." He said, "Are you ready?" She was quiet for a moment. The city moved outside the window. The Upper West Side at 6:47, alive in all its ordinary ways. She said, "I have been ready for 3 years. I was just waiting for the truth to catch up." He reached across the table and took her hand. Not urgently. With the ease of a man who has finally understood that the thing he was afraid of losing is not going anywhere. She turned her hand over and held his. He said, "I want to say something." She said, "All right." He said, "3 years ago, before I knew you, I was a man who had convinced himself that the safest way to live was to stop wanting anything that could be taken. I was very good at it. And then you answered a question in a lecture hall that I could not quite finish, and I thought, there is someone who reads the footnotes. And I went home that night, unable to stop thinking about the fact that someone like that exists in the world, and was sitting 15 feet in front of me." She said, "Most people skip the footnotes." He said, "I know." He looked at their joined hands on the table. He said, "I want you to know that nothing that happened in that courtroom would have meant anything to me if it had not also meant that the truth about you was finally on the record. That your work, the work you did at 26 years old, alone, at real cost, with no one standing beside you, is now documented correctly for what it was. Correct. Sound. Right." He said, "I am not going to stop saying it." She reached up and touched the side of his face. "Just briefly. The way you touch something to confirm it is real." He closed his eyes for a moment. And in that moment the federal judge, who had spent 11 years perfecting the art of needing nothing, looked exactly like what he was. A man who had found the one thing worth being uncertain about and chosen it anyway, every day. In the quiet of this kitchen table, and the amber evening light, and the worn Kindle, and the legal pads, covered in small, precise handwriting, that had turned out to be more powerful than anything he had ever presided over from a bench. She said, "You forgot lunch again." He said, "I forgot lunch." She said, "There is soup." He said, "I left it for you." She said, "I left it for you." They looked at each other. He said, "We should buy more soup." She said, "I will add it to the Amazon order." She stood and went to the stove. He picked up her Kindle and turned it to the page she had been on and read for the 40 seconds. It took her to heat the soup and then set it back exactly where she had left it, open to the same page. Outside, the lights on Fifth Avenue were coming on. The Manhattan skyline was doing what it always did at dusk, becoming something between a city and an idea of one. The world below did not know, and did not need to know, that the quiet woman in the linen blazer had sat in the last row of a federal courtroom that morning and, without saying a single word inside it, had ended a corrupt career, and cleared her name, and proved, for the 340 families in Queens, and for every woman who has ever been told her documentation was the problem and not the truth in it, that patience and precision and the refusal to abandon what is right are the most durable weapons any person will ever carry. The city did not need to know. She knew. He knew. The truth knew. And the truth, as it turns out, does not need an audience. It just needs to be true. Marcus Aurelius was a Roman emperor who wrote notes to himself in the middle of the night, not for publication, not for history, just to stay clear. He wrote, "You have power over your mind, not outside events. Realize this, and you will find strength." Wren Calloway-Ashford spent 3 years being told that the truth she had documented was a lie, that the person she was, precise and unwilling to be silent about injustice, was the problem, that the right thing to do was recant, move on, accept the version of the story that the powerful people had written. She did not argue with them. She did not fight them publicly. She went to work for $18 an hour in a windowless room. She read on the subway. She annotated her Kindle. She wrote memos on legal pads at midnight and placed them on pillows and trusted the man who had said, "Then let us make sure your name gets clean." She won, not by fighting harder, by being right, and patient enough to let being right do its work. Here is what the people who destroyed her never understood about documented truth. It does not expire. It does not get tired. It does not decide it is not worth the effort anymore. It just sits in a public archive with the original date intact, waiting for the morning when someone who knows where to look opens the right file. Sabrina Voss had power. She used it as a shortcut and a performance and a tool. And when the document was found, all of that dissolved. A press inquiry on courthouse steps, a phone call that went to voicemail, a career that ended in a dark office with a portfolio in a drawer. Wren had nothing except her precision and her patience, and one man who came home every evening and placed a pen on the kitchen counter and became, for whatever hours remained, not a position, but a person. She did not need to be loud. She did not need to be seen. She just needed to be right, and to keep being right, until the room had no choice but to agree. Do not confuse silence for weakness. Do not confuse stillness for surrender. Do not, for even one moment, underestimate the woman in the back row who is reading the footnotes, because she already knows how this ends. She has known since the night before.